Welcome to Juris Stupidity, a video podcast devoted to bringing attention to butchered legal terms and concepts. This episode is about precedent. A common mistake by commentators in social and regular media is what they refer to as precedent. But first, I must acknowledge that there is generic use of the term precedent, namely something that simply precedes another, with no legal implications, a thing before another thing. The kind of use of precedent addressed in this podcast is when commentators mistakenly use the term to mean a court decision that can have binding effect on future decisions. This mistake happens commonly with reference to both civil and criminal cases. For example, a commentator in a recent news report on a musical celebrity filing a lawsuit against an entity who used artificial intelligence to manipulate the celebrity's voice and work stated without hesitation that the trial court decision could create bad precedent. Wrong. A different recent news report had a commentator covering an upcoming federal criminal trial expressing concern over the precedent the trial court could set. Again, wrong. Binding precedent is not set by trial courts. Ever. Period. To understand how these commentators were wrong, one first needs to know what legal precedent is. It is, quote, a decided case that furnishes a basis for determining later cases involving similar facts or issues, end of quote, from a legal dictionary. It is well established in the federal court system that decisions in trial courts, otherwise referred to as district courts, create no binding precedent at all. The principle is so plain and uncomplicated, the United States Supreme Court has dispensed with the entire question merely in a footnote, saying, quote, a decision of a federal district court judge is not binding precedent in either a different judicial district, the same judicial district, or even upon the same judge in a different case, end of quote. Simply, there is no precedent whatsoever anywhere. Precedent only becomes binding from appellate courts or higher, and the higher the court, the more binding the precedent is. So when you hear or read about some talking head raising alarm over some trial court decision as precedent, you will know that it is only an example showing the speaker is wrong.